Good afternoon to everyone at today's public hearing of the Vetting Commission established under Law Number 65 on the external evaluation of judges and candidates for judges of the Supreme Court of Justice. I'm Scott Bales, the chair of the commission, and I declare this session open. The hearing is being conducted under Law Number 252 of the year 2023 on the external evaluation of judges and prosecutors and amending some normative acts, and under the Commission's Rules of Organization and Functioning. Subject of today's hearing is Angela Bostan, a judge of the Central Court of Appeal, previously known as the Chisinau Court of Appeal. Judge Bostan, welcome.
Judge Bostan.
As noted from the hearing notice on May 22nd of 2025, the Superior Council of Magistracy, by decision number 237, rejected your evaluation report and ordered the commission to resume the evaluation procedure. Thus, in accordance with Article 20 of Law Number 252, the commission invited you to attend today's hearing. You will see we're joined by 8 other commission members present there in the hearing room. Looking from your left to right are Lillian Ansu, Marcel von Vettering, Julian Russo, William Brower, Vice Chair Andre Bevel, Commission Member Lavely Perling, and then Commission Member Yuri Gatskin. And on video, in addition to myself, is Commission Member Garrett Sprenger. Also present is a photographer who will take some photographs briefly at the start of the hearing, and you will also see members of a secretariat, possibly members of the public and the media. Hearing will be conducted with interpretation between Romanian and English. To allow for more accurate interpretation, I ask that everyone speak slowly and clearly. Only one person should speak at a time. The proceedings are being recorded. Recordings of the commission hearings generally will be available online at the commission's website, www.vettingmd.eu, within 3 days after the hearing. During the hearing, members of the commission may ask you questions. We ask that you answer them truthfully and completely. Your explanations are important to the commission in verifying your financial and ethical integrity. At the end of the hearing, you'll be given an opportunity to make a brief closing statement. In posing questions, we will consider your privacy and, where required and possible, the privacy of your family members and close persons. So we will omit unnecessary details on such things as ID numbers, specific residential or street addresses, bank account informations, and so on. For the sake of privacy, we ask that you do the same. I will begin by briefly reviewing the evaluation process for Judge Bostan since the completion of our initial report. We previously, on the 2nd of April 2025, adopted an evaluation report recommending that Judge Bostan promote the external evaluation under Law Number 252. As noted, on the 22nd of May 2025, the Superior Council of Magistracy, by decision number 237, rejected the evaluation report and ordered the commission to resume the evaluation procedure. In the period between the 24th of June and the 6th of July, Judge Bostan was asked and answered an additional round of questions. On the 5th of September, we notified the judge of the commission's remaining doubts and asked her to attend today's hearing. Judge Bostan, do you wish to make any corrections or additions to the answers you have provided to our request for information?
Thank you. I am not going to make any corrections. May I only mention that I upheld the information and documents that I have provided as a result of the SCM decision, as a result of notification from the Commission on the need to add or supplement my answers to the doubts found in the SCM decision. I support fully all the evidence and information documents I have provided to you so far.
Excuse me, I do not have English translation.
Yes, and I also not hearing translation.
Can you hear the interpreter now?
Yes.
Yes.
Shall I repeat again what I have mentioned?
Yes, because both Commissioner Steiner and I are unable to
Yes, please. Yeah.
understand.
I have. What is this now? Okay.
So I will repeat. To answer your question, dear Chair, I would like to say that I do not have any additions, corrections to be made to the evidence, documents, information I had presented to you as a result of the doubts expressed by the Commission. Therefore, I support them fully and I am ready, if needed, to provide details to you.
Okay. And with regard to the questionnaires that we sent you in the first phase of the evaluation process, the Return to Ethics questionnaire and declarations on April 30th, 2024, are there any changes to those documents that need to be made that you've not previously provided to us?
So, if you ask me about changes to those documents or questionnaires, no such changes, modifications have occurred. I only specified that what I provided to you during the hearings before the Commission, before its report was ready, and I provided some relevant evidence regarding the situations that were mentioned by the SCM in its decision.
Okay, well, we appreciate that. And some of the commission members, I'm sure, will have additional questions to ask you today. We will try to keep our questions short and to the point, and we would ask that your answers be short and to the point as well. I believe Commission Member Lillian Ansu will start this afternoon's questions.
Good day, dear Judge. Good day. We are at the re-evaluation stage. In order to clarify all the circumstances, the Commission members will ask a number of questions. Can we start with the issue regarding purchase of Lexus vehicle? For your kind clarification, may I please make a brief recap of this purchase. You purchased Lexus in 2020 and you paid 250,000 Moldovan lei. At the same time, you have covered additional costs for repairs in amount of 21,000 shortly after you purchased Lexus vehicle. Nevertheless, according to the Commission's estimates, you had a deficit, or you lacked around 121,000 lei to conclude this transaction. In the previous round of the question and answer session, you explained that you had an agreement with the previous owner, and the previous owner accepted a delayed amount, payment of the full amount. We require clarifying from your side in order to understand the events. I would like to show you the step-by-step. So on November 2nd, you signed the purchase selling agreement with the B in order to keep its, not to disclose to buy an X Lexus manufactured in 2014. That contract had a standard clause confirming the fact that the previous owner was transferring the vehicle to you, and you paid the price of the vehicle and become the owner of the vehicle. On September 2nd, 2020, you became the owner of this vehicle. You came to the Department for Registration of Vehicles, and your vehicle was subject to technical inspection. On September 4th, you recorded an insurance policy premium for this vehicle. Despite that, you informed our Commission that that vehicle required repairs after you have purchased it, and those repairs were finished on September 12th, 2020. Based on these events, we need to clarify 2 points. Since you made significant repairs of this vehicle after September 12th, and when did you become effectively the owner of the vehicle? 2 questions: whether any repairs were made, and when you became the effective, real, actual owner. Thank you. Indeed, on September 2nd, 2020, I purchased this vehicle. The vehicle had some problems which required some improvements, and I had to pay for those improvements, despite the fact that I provided these pictures confirming the degree of need to renovate, to repair the vehicle. This vehicle was could be used. Those were rather cosmetic, not technical problems that had to be eliminated. Therefore, I became the owner of that vehicle immediately after the purchase-selling contract was signed. This vehicle was retained at the repairs shop by the person through which I purchased that vehicle. This person is identified and mentioned in front of the Commission in the past. Probably, I cannot recall the developments on a daily basis. Probably after the contract was entered into, this vehicle stayed in repairs shop. As to the insurance premiums for the MTPL, that is a legal requirement as a new owner for myself of that vehicle, and the insurance was purchased immediately after the selling contract was signed with the insurance company. But the repairs works made to the vehicle were made before or after September 12th. So let's say that you registered the purchase on September 2nd, and then you sent it to the repairs shop. I sent it to the repair shop after that. I cannot recall the date when the vehicle was sent to the repair shop and the date when the vehicle was taken from the repair shop. I don't recall some consecutive developments in the repairs because it required some changes in certain parts of the vehicle, in the meaning that the vehicle needed some interventions. To my knowledge, this process was a lengthy one, a staged process of interventions and repairs stage by stage. Probably they lasted after September 12th, but today I cannot say with certainty the period of time and days, because I didn't intend to recall, to memorize them day by day. Thank you. On September 2nd, when you registered your ownership right on Lexus vehicle, you at the same time were the owner of Honda CR-V vehicle. You are the owner of that vehicle, and you have disposed of or sold on October 16th that vehicle. Could you please explain to us what happened to Honda CR-V between September 2nd and the date when you sold it, when you disposed of it? This vehicle was left in the custody of that person that intermediated the purchase by myself of Lexus, based on the agreement that that intermediate would take care of reselling the second vehicles and helping me reselling it, because that intermediate was doing such intermediation and reselling, and he had experience in coping with technical issues in the vehicles that I was not able to cope with, and I couldn't do by myself this reselling of our vehicle. Our agreement, understanding was that the second vehicle stays in his possession for him to sell it and to help me, assist me to resell it. So you handed over the vehicle on September 2nd or later? A few days, maybe not on the September 2nd, but a few days after September 2nd, immediately after that date.
And by the way, I want to have a clarification. There were a few situations after giving it away, lacking the transportation means, because the Lexus was not was in the repair works. I've asked the respective person, and I took this automobile, this vehicle, in order to use it in some situations that supposed emergency usage of this transportation mean. So as long as it was on sale, I had access in a few situations to this vehicle. Thank you. In the second round of questions, in the previous evaluation or initial one, you declared that you paid for Lexus in 2 tranches. The initial rate was 80,000 lei, paid on 2nd of September, on the day of signature of the contract. And the second one was 170,000 lei that were paid on the day you sold the Honda CR-V on 16th of October 2020. At the same time, you affirmed that Mr. Webby accepted this way of payment in 2 tranches because he was planning to leave the country, and there was a declaration from his side that is confirming this fact. At the same time, according to the border police, Mr. Webby did not leave the territory of the Republic of Moldova from 15th of August up to 16th of October. Here we have a question: if you can offer additional documentation that could confirm that Mr. Webby was outside the country in the period September-October 2020, or to explain what happened. About the fact he left the country just in October, found out it from the Commission and the questions that were addressed. Evidently, I've tried to ask him and clarify the situation, and I received the answer that when he sold the auto vehicle on 2nd of September, being in the country, but actually previously working in Ireland, if I'm not mistaken, he was said by his employee that it is needed to go back to the workplace as soon as possible, because his availability was on the period of pandemic, when the majority of the enterprises were not functioning. Respectively, by being summed and having the certainty to go that he would go back to Ireland to work. As a priority, he decided to give away the Lexus vehicle. And he accepted, and he was actually glad that he needs to go back, respectively selling this vehicle, and in parallel he solved some aspects related to the arrangements of his going back to Ireland. And in this situation, coordinated with the employee, had some time needed for the arrangements. So respectively, he went back to Ireland, and by present moment he works and lives in Ireland. This is also certain. So we have anticipated respective situation with signing contract, starting from the firmity of his decision to sell this vehicle as a priority, but also not to leave it for the last day, the arrangement of documentations, because he could understand that he could leave any day when he finalizes all the logistical arrangements when it comes to going back to work to Ireland. I would like to mention here, if eventually I knew this situation, that both of us would understand that it would take longer to have these arrangements, and that my automobile vehicle will be sold within this period of time, evidently I would leave this transaction, legal transaction, for the moment of selling the Honda CR-V. But I didn't know, we were not knowing an exact date when he will leave and or concrete date when there would be a potential buyer of Honda. I'm looking into this question from the perspective of syllogism. I'm accepting the payment into tranches because I'm leaving the country, as he is saying, but I'm questioning, if I'm not going, then I'm not accepting it because I need to leave. And I don't know if I'll be in the country at the moment that the other vehicle will be sold. But the certainty of the fact that we have conditioned the procurement and payment, full payment for the vehicle from the sale for Honda vehicle, it results from the documentation offered from the person who bought Honda and the owner of Lexus and the person who mediated this transaction. Thank you. As well, in the initial phase of hearing, you have mentioned that the procurement of a Lexus was intermediated by another person with initials DR, and also he received the second tranche for Lexus, as it is right, if it is right. Please let us know how Mr. DR mediated the sales for Honda vehicle. He was looking for clients, he had the promotion of the announcement of the sale. Maybe you could offer some discussions, texts, mail, SMEs, like text messages with Mr. DR. Yes, that was a person that assisted the owner of the vehicle in order to bring this vehicle from abroad. I've annexed this document from the owner and the mediator. There was an agreement on the management approach for the vehicle. For this person, we not identified through some calls, but through referrals, through common acquaintances, and they referred to him when I was discussing the intention to procure a vehicle and to sell mine. So I've requested his support, and he has as his main job an automobile service, and one of his activities is repair works and is selling the cars, and he is also the relative of the owner of the car. So at the moment there was the owner and respective person when we signed the contract. Later on, all the discussions were by phone, but also sometimes maybe from some text messages. I don't know, maybe if I open the discussion, but I'm not sure if they are preserved for 5 years in the phone. When I sold Honda, the owner of Lexus was not present, so we had only the buyer, his relative, and respective person that was responsible for the sale and the negotiation process. And this difference of amount was transferred to this specific person. And practically, I was not the owner of this money because the buyer of Honda transferred this money personally to this person, to Mr. Diar, to not give his name. Do you remember if Honda was posted on any sales platform or he negotiated? I don't know. I'm not aware, but I know the professional activity he has is the repair works and sales of the vehicles he is repairing or managing. And he is also the good acquaintance of other people that I know, and that trust was created due to this relation. In your previous declarations, you have mentioned that Mr. Diar, as you have mentioned right now, he was empowered by the owner of Lexus in order to organize the sale of this car. So respectively, you offered this empowerment document, and it was available for 1 year, but respective document was empowering the other person to import another Lexus, but not to sell the one that you have procured. That is why he did not participate in the contract signing, because he had no empowerment between me and the owner of Lexus. I actually, about this empowerment document, found out now when we discussed once again all the details, and he told me to be clear that me and the owner of the car, we had some relations of trust. So we are talking about the DR and the owner of the car. So that is why this empowerment was not a confirmation of a specific situation, but general, when it comes to the confirmation that it wasn't a random person between me and the owner of the procured vehicle, but a person that acted based on a document. Another aspect related to the declarations of VB and DR that confirmed that a contract of sales of Lexus was signed in August, but we have discussed by now, and we are having the documents that are saying that the transaction was done on 2nd of September. If you could explain why the respective gentlemen are talking about the contract in August. there is a discrepancy about the time. Maybe they are not lawyers or legal people, and they consider that the transaction and identification took place in August, and if I wouldn't be in the situation that he would need to leave urgently according to his declaration, this contract could be signed not on 2nd of September, but when the Honda was sold. So the identification, if you understand, when we presented ourselves on 2nd of September to register the contract, we needed to schedule at the Agency of Public Services, and this scheduling, the programming, takes time, and the longer the period of time, then the costs are lower. So in order to have it urgently, for example, in August, that would be more expensive. So that is why the identification of the vehicle, the understanding, the agreement and discussions when it comes to the price and way of payments took place in August, but the scheduling at the Agency of Public Services also was in August for the first occasion without additional costs, and to be within the time limits of the person who was selling the vehicle, considering he had the luggage already ready to leave the country. Thank you. Let's discuss the moment of property of Mr. DR of the Lexus vehicle as a guarantee for the second tranche for the procurement of this Honda, not Lexus, Honda. Yes, exactly. So you've mentioned that Honda CR-V was as a guarantee for while waiting for the second tranche for the procurement of Lexus, and you had signed the declarations of the buyer of this vehicle, according to which Mr. DR organized the sale of Honda on your behalf, the test drive and all the other relevant actions. So Mr. DR confirmed his participation for the sale of Honda in a declaration submitted to the Commission, but never mentioned he was in possession of Honda vehicle. Thus, in his declaration to the Commission, Mr. DR mentioned that he was in possession of Lexus up to the second tranche of 16th of October. So the exact wording of Mr. DR, Lexus was in his custody for 1-2 months after the repair works for the vehicle. I would kindly ask you to explain why Mr. DR is offering this information in his declaration. Probably this situation confirms once again that explanation that I offered, that vehicle stayed at him inclusively for the need to finalize according to some technologies the repair works, but the fact that this situation was conducted and executed by Mr. DR was confirmed by the buyer of Honda vehicle, that confirmed legally that everything related to the sales and procurement of Honda and all negotiations took place exclusively with Mr. DR, inclusively the transfer of the sources, and he mentioned that his involvement is conditioned by the fact that after the sale of Honda vehicle, I need to pay this price in order to fulfill the price for Lexus. I would like to add a remark, a clarification here. Evidently, the respective situation was a special one, But at the same time, when we're talking about selling, procuring, so well, selling a vehicle with the condition that I'm procuring another one, for that period of time, I did not know about these criteria and exigencies that I would need to go through during the vetting procedure. So I've acted in a way with trust based on some mutual insurance between me and this person, inclusively a situation that was confirmed by the Honda buyers. Evidently, if I didn't know a few aspects, maybe the things could be, from the legal point of view, much better positioned, and there wouldn't be a problem if this contract of selling, buying would be adjusted to our situation, and this payment were reflected in this document. So the lesson learned of this situation, I have taken them, and recently I've sold Lexus and I bought another one, as well with the condition that one tranche was paid at the moment of transfer of vehicle, and the other one during the sale of Lexus. So this lesson is perfectly learned and will constitute a lesson learned for me for the future, and a referral point to start from, being aware that each situation should be reflected from the legal point of view with specific details. Thank you. Please let me know, according to the entire story of the automobiles, you offered no empowerment for Mr. DR. He had no empowerment to act on your behalf. It was not needed, because I was present at the signing of the contract, legal contract. When it comes to the management, I had the trust for this person, starting from the fact that these people mediated, they were common acquaintances, and that was a very serious person. And your communication with Mr. DR was by phone, not just by phone. Repeatedly, I came to the premises of his company, where he has also a workshop for repair works, where Honda was there, it was exposed there, where the Lexus was repaired. So I was aware with all the situations that were conducted. So it's placed at the outside, around Chisinau Arena. So he has a workshop, quite solid one, where I was going quite often. Thank you. Dear colleagues, if you have any questions regarding the Lexus, if my colleagues have no questions, I suggest we go forward regarding the Honda vehicle that was procured in 2015 for a cost of 175,000 lei, and according to the estimations of the commissions, you were in deficit of approximately 21,000 lei at the moment of procurement of Honda. Your explanation was that you have received a payment in advance of an alimentation pension from the child of father, and you received loans for a short period of time. So, in order to have this, according to the information the Commission has, the father of your child could not have enough income in order to have the alimony for the minor child. So thus, please explain the source of these payments. Thank you very much. I understand your question, and as I've mentioned, and I reiterated this now, I cannot offer you the specific details how this cost was fulfilled. I just mentioned that procurement of this automobile was not a planned one, but it was a need, emergency need, to solve the effect related to my transportation to the appeal court in Comrat. So my intention was to transfer, and I participated at the call to transfer to appeal court in Chisinau. So when I was told that I'm temporarily transferred, in order to solve the activity in appeal court in Comrat, I had the need to cover the need of transportation to this community, which is 70 kilometers away from Chisinau municipality, and there is no regular bus to Comrat. So as an emergency, I have identified this automobile. I took the loan from Moldovan Growing Bank, and I used all the financial reserves and procured these transportation means. And I would like to mention that was ensuring the transportation during the winter time, and I needed a safe transportation mean for winter season. In that situation, the specific details related to that this money come from the father of a child, or maybe acquaintances that I was looking into, I cannot identify because 10 years passed. But I would like you to take into consideration that when we have identified the minimum cash available at the beginning of 2015, it was an estimative, approximative indication. So certainly there were situations when some amounts were needed in order to solve on short term a financial situation. I was asking financial resources from the father of a child and other two persons that I have identified, and they confirmed it. But to indicate precisely that this source was from one person, I cannot tell that exactly. When it comes to the lack of financial availability of a father of a child, of my child, I would like to mention that this situation, if he's available financial in the quantum according of the needs of the child, he was always available, and he was receptive and open when I requested an amount of money. It happened when the child had needs. Where he was taking the financial resources from, I cannot mention, I don't know, but he had his cabinet registered, he participated in the court meetings, and he was always in activities. How he managed his fiscal reports, I don't know. Thank you. Additionally, you have mentioned that it was needed, or quite often you were taking loans from friends, inclusively for other reasons like procurement of smaller amount or emergent needs. When the Commission asked you to offer details regarding all these loans, you have not indicated any of them exactly. My question is why you haven't communicated about these short-term loans, and if you remember, to communicate to us as with the title of an example, when it was contracted and when you offered it back. Was it during the same year, or a loan that was taken from 1 year but returned next year? If you remember any events like that. Thank you for the question. I understood. So these loans were quite rare, and they were not going over 15,000-20,000 lei. Perhaps I was offering them back in tranches, but I was always aware when I was asking for this money, but these people were not multiple, 2-3 people that I knew that they have these financial resources and confidentially could offer them to me. Short term, usually it was in the situation that I know that in August, September, I will receive the vacation leave money, and I could return fastly this money. And from each salary, I could retain 2-3 months this amount in order to reimburse them by the end of the year. I have mentioned that these occasions were quite rare when I asked for these loans, 3-4, not more, when I had the emergency need to have some procurement for the household appliances, like for example when the heating system went down. So there were emergency situations, and I was aware that this amount will be reimbursed as I was negotiating them at the beginning of the procurement in 2, 3, 4 tranches, and usually by the end of the year these amounts were returned. That is why they were not reflected as debts in my declarations on income, because these amounts were covered from this personal income, and it was the same amount as entrance flow and input and output flow. And I was responsible to know that it's important to return the money by the end of the year. But that was more an exception than a rule. Thank you, colleagues. If you have any questions related to the automobiles.
Just one. Perhaps I misunderstood Madame Bostan, but when buying the Honda CR-V, you didn't have enough money. Did you mention that you took a bank loan then? No? Okay, thank you. That was all.
Yes, it was in an emergency, and the bank could not offer more than 100,000 lei because I was connected to some conditionalities, requirements related to the income declaration, and because there was no guarantee, the maximum available amount offered by the bank was 100,000 lei.
Also one question, Ms. Bostan. I don't know if I understand your answer correctly, but you bought the Lexus in the start of September. Then you left the Honda there at the same person. Did you take the Lexus after it was repaired with you, or didn't you have the Lexus available till the 16th of October?
Lexus vehicle was in a technical state that enabled or was possible to use it. It wasn't broken in such a way that I couldn't use it. I still could use it, but as the repairs in Lexus was done in stages for some reasons, for some technical reasons, Lexus was both used by me. It was for a short time in my ownership, but physically it was a longer time located in the repairs shop because of the staged repairs by the person that repaired. For example, as soon as a spare part was received by the workshop, during this waiting time I was using the vehicle. As long as they were using the spare part and making the improvements, the vehicle was at the repair shop. So after the spare parts were installed, until these parts were prepared, and until dyeing or coloring the vehicle, it was a longer waiting time during which I used it. But more time it was in the repairs workshop.
Okay, thank you.
Deci, haideți parcurgem mai departe.
Now
referitor
let's
la
look at the
chestiunea
following developments
privind achiziția
regarding the
apartamentului pe
purchase
strada
of
Lev
the
Tolstoi.
apartment located on Lev Tolstoy
Astfel, în
Street.
august
In August
2018, mama
2018,
dumneavoastră a
your
achiziționat un
mother
apartament
purchased
și un
an
spațiu de
apartment
depozitare
and a storage room paying
sumei de 1 milion de lei.
1 million
Iar
Moldova
în răspunsurile
lei.
noastre către
In your
comisie
answers
ați
provided to the
afirmat că
Commission, you
fratele
stated
dumneavoastră
that
a
your
contribuit cu
brother
30.000 de euro
paid 30,000 euro,
mama și
and in
mătușa au
addition, your
contribuit cu
mother and
20.000
aunt
de euro
provided
pentru achiziția
another
acestor bunuri
20,000 euro to buy
În
the
rândul său,
apartment and
comisia a
storage
putut
room.
documenta
The Commission,
contribuția
therefore,
a
was able
30.000
to
de euro a
document
fratelui
the contribution of 30,000 euro from your brother.
și suplimentar
And in
punerea la
addition,
dispoziția mamei noastre
the
aproximativ 12.000 de euro.
12,000 euro from your
Sursa care nu a
mother.
putut fi identificată,
We couldn't
deci
identify
rămâne
the
aritmetic 8.000
remaining
de euro.
8,000
În
euro
cadrul
you
evaluării ați declarat
received
că
during the
cei 8.000 de
evaluation. You
euro
mentioned that the
ar fi
8,000
provenit din
euro
activitatea comercială a mamei
were
noastre la
generated
piața
from
locală.
the
Ați
selling
furnizat mai multe
activity of your
declarații
mother
ale
in the
martorilor privind
market.
activitățile comerciale
You
ale mamei.
provided
Iar
proofs
cu
from
toate
witnesses
acestea,
on
comisia nu a
the
fost în măsură să
activity of your
documenteze
mother, but the
proveniența
Commission
banilor
was
respective.
unable to
Vă rog
document
să
the
ne
source, the
explicați
origin of this amount. Please explain
cum au fost
how
făcute aceste acumulări,
this money was
de ce nu
accumulated
există
and
documentarea
why
lor
there are no
și
documents confirming the
cum
earning of
puteți
this
să
amount.
comenta
And
această
how could
circumstanță
you
referitoare la cei
comment
8.000
these
de euro
circumstances regarding the
care
8,000
momentan
euro,
sunt într-un
which
vid?
currently are not documented as a source, their origin? I believe that the Commission is aware about the details and how the apartment was purchased. Therefore, I will refrain from repeating the circumstances. May I instead mention the fact that I will maintain my position that I mentioned earlier in front of the Commission. It was confirmed by my mother, by my aunt, that this amount of 8,000 euro constituted inclusive the accumulations, savings of my mother that was very actively, professionally speaking, before being injured, that made it impossible for her to work. Therefore, I did my best to once again confirm in front of the Commission through the witnesses' declarations, statements confirming that my mother worked as a merchandiser, as a seller in the market, placed in her locality, and I would like to confirm that she had the possibility to earn that amount. Why she didn't keep records, or why she didn't deposit that amount in a bank, and why she didn't attempt to adjust these financial statements, you have seen her, heard her explanations. I didn't stay with my mother. We didn't have a joint financial activity or in situations that would require my involvement. My mother rather helping my brother that was part of their household, and she coordinated with him rather some perspectives or plans of hers, including financial ones. My mother never bothered me regarding to ask any money, financial support from myself to her. She was fully financially independent before 2017, and she was secured financially based on her activity. I could only find out some aspects occasionally, but not on a constant basis. The documents, what I presented to you, and the certificate for the mayor's office confirm that my mother conducted this trading, commercial activity. She was professionally active and working during that period of time, and as confirmed by my aunt, both my aunt and my mother had some plans to purchase the specified apartment But my involvement in these issues, including the right to use it, was conditioned or was due to, my involvement was due to the worsening of my mother's health. If my mother was health was well, I wouldn't have interfered or helped my mother with this support. Last but not least, the situation that occurred in 2022 made my mother's sister find herself in an impossibility to return to Moldova and live, stay there. As she is a pensioner in the Russian Federation, she cannot receive the Moldovan pension, and she cannot return to Moldova to stay together with my mother. Please believe me, this is rather a burden for myself than an advantage. I mean, the fact that I have to provide this support to my mother, and if the situation wouldn't be the way it is, I would be able to settle my issue regarding my own apartment in a better way than I can cope now. I cannot leave my mother without supervision during the winter, during the heating season. As my mother stays in that apartment, I have to cover some so I cannot have two apartments to pay for both apartments utilities. It would be a too big financial burden for me. My aunt is returning to Moldova, and some aspects regarding her return and establishment in Moldova will be settled, as my aunt returns next week, and if needed, she can come and provide some details. Thank you. At the same time, can I ask you to tell us whether you are aware about this savings of 8,000 euro, this amount saved? Has it been gathered over the period of several years? Was it a result of some savings in cash kept at home, or this amount of 8,000 euro represents an amount that was earned as a result of a larger transaction or sale? Or was it gradually gathered for a longer time? How was it gathered? I only know from my mother's statements, which is more than 80 years old. She did her best to provide details, and I submitted a confirmation paper to you of our discussion with my mother. She says that this money is a result of a gradual gathering of some savings she did on purpose for some situations and purpose, specifically to buy with her sister an apartment, to stay there together with her sister, because her sister is alone. She never had a family of her own. She never had children of her own. And this is the explanation provided by my mother. She worked hard to secure some savings for herself to settle this specific issue. At the same time, your mother received several international money transfers from your brother and your aunt. This thing suggests that your mother was financially independent relative to your brother and her sister. Now the question is, despite the fact that she had some savings in significant amount, she still received international money transfers. What was the purpose of that financial transfers to her? Based on my mother's explanations, that money transfers, on the contrary, do not suggest a financial reliability or dependency of my mother on her son or sister, because these were considerable amounts. It suggests that my mother, together with her sister, gathered the big amount specifically to purchase real estate. I have to say that I am aware, and I was even asked also by my aunt and by my mother to identify real estate in Hâncești during the time I lived and worked in Hâncești, so as for them to be able to buy that real estate and to settle closer to the place I stayed and closer to Carpinenia, the village of origin of theirs, so as to efficiently manage the amount of money my mother was gathering. Therefore, on any occasion, her sister was transferring money to my mother. The moment my brother was gathering some amounts, he was also transferring those amounts to my mother, and these amounts didn't was not something requested by my mother. I could see transfers of 1,000 euro, 1,500,000 euro, 1,500 euros. She never spent the amount. That is why these amounts are part of that amount, big amount, and these transfers confirm once again the agreements my mother had with her sister, inclusive. Thank you. Another dimension of this purchase constitutes the loans, the borrowings made by your mother to Miss V.M. According to her statements, your mother gave or borrowed money to that lady several times. All in all, the total amount of the presumed borrowing amount was 3,000 up to 5,000 euro, as stated by your mother between 2009 and 2013. Ms. V mentioned she used the money that she borrowed for renovations and construction works. In this regard, I would like to ask you whether you recall or you are aware of the total amount borrowed by your lent by your mother to Miss B.V. How can we interpret the amount of 3,000 up to 5,000, which is one amount that there is, or is it two amounts of one of 3,000 and another of 5,000, or is it a total amount lent of 8,000 provided installments? Mathematically, how can we reflect this story? As a priority, I would like to mention that I have learned about this money lent by my mother or during the evaluation I was a subject of. When I asked my mother this question, and I told her that the Commission has some doubts whether my mother had these savings gathered by her, and I asked her how this amount can be confirmed. So she asked, how can this fact that I borrowed this money to this lady can be confirmed by the borrower? Therefore, we identified this person that borrowed money from my mother, because I also knew her, but I didn't know about these financial relationships between my mother and that lady. What I could find out was that my mother lent her first time 3,000 euro for more than 1 year. Then that lady returned back that amount, and that strengthened my mother's trust in that amount. And in addition, my mother charged percentage as an interest rate for that money lent to that lady. So after the first amount was returned, that was a sign that my mother could be certain to receive the following sums from that lady. My mother granted that lady as after the first return of reimbursement of the 3,000 euro with small interest rate charged by my mother.
Vă mulțumesc. În același timp, potrivit estimărilor care le-a
At the same time, according to the
făcut comisia, doamna Venie nu a avut
estimations or
suport de a
constatations of there was no evidence, fiscal evidence
gestiona
in order to
asemenea sume, sau, mai
manage
bine spus, pentru a le putea rambursa.
or
Poate
reimburse.
cunoașteți dumneavoastră ce practica, ce
Maybe
tip de
you know what
activitate
type of activity
sau
she was
ce activitate
practicing,
economică avea doamna
what
Venie, care i-a
Mrs.
permis
Veme,
să restituie acest împrumut
in order
oamenilor.
to reimburse this amount to your mother. I know that she was a manager or some implications in the management of advertisement local or company, but I don't know details, Honored Commission, because she confirmed legally that she asked for this loan. I don't know if she was a declaration subject on the income, but this transaction between my mother and herself took place, did not oblige me to verify her financial disponibility. Was this amount returned fully or in tranches? But I know that that person has this type of activity. Dear colleagues, if you have any questions related to the real estate,
Doamna Bostan,
yes, Mrs. Bostan.
avem așa o situație
We
în
have a
care
situation in
din
which,
toată informația pe care am
from all the
luat-o
information that we
comisia independentă
accumulated
au
as
fost
the Commission
prezentate de dumneavoastră,
was presented by
rezultă
you,
că, pe de o
results
parte,
that on one hand,
în perioada relevantă,
in the
mama
relevant period of
dumneavoastră avea o
time, your mother
activitate
had a commercial
care
activity
îi permitea
that
să
allowed
facă
her
economii,
to have some savings,
să acorde împrumuturi.
to offer
În
loans.
același timp,
At the
în
same time,
aceeași perioadă,
in the same period
ea
of
primea
time,
constant
she was receiving
transferuri
constantly
internaționale cu
international
titlul de ajutor
transfers with
de
the
la
title
fiul ei,
support
la fratele dumneavoastră și la
from your
sora ei. Cum explicați această
brother,
contradicție?
so her son, and from the
Pentru că dacă ea
sister.
avea o activitate comercială,
So she had a commercial activity as it is declared. How you could explain that? Why it was needed to receive help, financial support? I have mentioned that these amounts were not sent with the title help or support. These amounts were sent by her sister with a title to save, to reserve this money in order to realize some aspects related to the procurement of the apartment. When it comes to my brother, on one hand, the Commission doubts and asks me why this brother did not transfer from the bank institutions. On the other hand, the Commission asks about those who were transferred and doubts that they were in the support of the affirmations of these ones in order to accumulate or ensure those savings done by my brother as a result of his activity. These were not with the title of support or help. They were with the title to be accumulated. So my brother was accumulating initially for aspects related to the needs and necessity to come back to the country and have an activity here. And it was confirmed by him because he wanted to procure some terrains to launch himself into the agricultural sector, and those money were inclusively transferred to his father-in-law, so they were collected in order to develop as an economical activity in the country. And when my mother had this traumatism, these money were directed to solve the aspects related to the procurement of apartments that were not in the plans of my brother, but it was a desiderate for mother and her sister previously, and these savings, considering the increase of the price, they were not enough to implement those plans he had.
Haideți să concretizăm atunci.
So let's specify then.
Deci, declarația noastră
Your
este că
declaration
toate
is that
transferurile
all the
primite
transfers
de mama dumneavoastră,
received
de
by
la
your mother
fratele
from your
dumneavoastră
brother,
din Italia și de la
from
sora ei
Italy,
din
and
Federația
her
Rusă,
sister from the Russian
au
Federation
fost
were
convertite în
converted
economie.
into the economy or savings. From the explanations of my mother, yes.
Nu mai am întrebări.
I have no questions.
Yes, Madam Bostan. Just for my recollection, your mother was on the market with textile and clothing? And was she on the market on a daily basis, so every day of the week?
No.
How many days a week?
No.
De fapt,
Actually, usually she was for 2 weeks on the 2 days on the week, on Thursdays and Sundays. And this market was not operating every day, but I would like to mention for a short period of time when my mother offered her support and educated my child because I was working. I went to work when my child was 4 months old. In the period of 2003, my mother only on Sundays was going to the market. And during the week, she was nannying my child in Hâncești.
Have you got any idea of the turnover your mother made on the market?
I've asked about this information currently. I didn't know about this information those days, but monthly these amounts, of course, along the years they increased because the prices increased as well. But I think monthly not more than 3,000 lei, maybe 4,000 lei. But 4 was when the sales were in an active phase. During the winter season, they were smaller. In summer, maybe more considerable. When the inhabitants of this community were coming from abroad, coming home, and they were active to procure, especially when there are ceremonies like weddings, like baptizing events. So depending on the season and capacity of procurement.
Thank you. And I have read in the file, but please forgive me, I forgot how long. How many years did your mother work on the market? I think it was 3 years or something, but you can fill me in on this.
Over 10 years.
Over 10 years. Okay.
So at the moment, my mother started to offer support and nannying my child, that in 1999-2000, she was already active on the market, and she finalized this activity perhaps in 2012-13, something like that. So she was involved less and less. And it was a period of the last 2-3 years when she was less active, considering her age.
Yes. Then in that respect, did your mother have another income as well, apart from the market income?
Of course, she had a household. Agriculture, she had 2 terrains, approximately 2 hectares. And she was developing them, and she was growing quite good household, as a good any person good in the household in the countryside. And she was managing to have these birds as well, to take care of them.
And this contributed to her household? Okay.
Of course.
She didn't sell the goods on the market, the crop and the birds and whatever.
She was selling. Yes, she was. The agricultural harvest crops and the birds she was growing, and I cannot tell you how exactly, but even people were buying from her house. There are people that were asking her, requesting the agricultural products that my mother had in her household, inclusively the hens, eggs, fruits, everything that is needed. Actually, I would like to mention that by now, from this point of view, my mother is absolutely active, considering that her health situation is better, and living in the countryside, she's still growing and keeping the households together with the person that is helping her. And my brother is at home right now, so financially we are doing relatively well.
Okay, thank you.
Thank you too. Mrs. Bostan, if you know and can tell us in your community, your mother is having the economical activity. There was a tax perceived by the public administration for the market activity. If there is any evidence on the payments, I have tried to ask my mother, but considering that from this last period of time, there are more than 10 years, she said that she did not store or preserve this type of documentation. But I kindly request the Honored Commission to have a confirmation certification for the mayoralty. And I understand that my mother, initially when she started this activity, she had an entrepreneurship patent, so the documentation, and she did not prolong it or extended it. And this is showing that this activity took place. And I don't think that there is the only case when these types of things are happening. In the situation that many persons, especially elderly ones, avoiding to respect exactly the legal provisions, especially in the rural areas. And the second question, could you tell us, please, when you have decided together with the relatives to procure this apartment, inclusively with the support of the brother, and if your mother had this 8,000 euro at that moment? And another question, what was the rationale behind it so that the brother accepted such a big contribution for the procurement of the apartment? Thank you. So the rationale of the brother was as simple as human. That was his reaction to the fact that we couldn't find a different solution for that moment in order to ensure this care for the mother, considering that it started in 2017 up to 2020. 17th of August up to 20th of August, she was immobilized because of a trauma she had. Respectively, all the financial resources that were in the possession of my brother in order to ensure his own plans for the different directions were or constituted the contribution to the procurement of the apartment. On my side, not being able to offer as material support, also in order to cover the obligation, in order to offer support to my mother as much as possible, accepted to move, to live with her, and to supervise her, and to offer all the maintenance and support she needed. And in the current moment, I have tried to bring my relatives to the confirmation that this apartment is strictly under their property, in order to document these contributions. So respectively, the sister of my mother is coming back to the country, but the amount of 8,000 euro that were retained by the Commission as a difference from what the Commission considered my mother heard was the amount that my mother owned, additionally to the amounts as a result of the sale of the apartment, and this 20,000 euro she had in 2017, they were the investments she has done into this apartment. That's it. Could you tell us about the vehicle? Why don't you have an exchange contract with the additional payment? That would be an exercise that would be much easier than to have this sales with later payment and so on, and other exercises that we went through today. Thank you for your question. I understood it. So the exchange contract was imposing that Lexus should be exchanged for Honda with the owner of the Lexus. But because he needed to leave, it wasn't clear if he could be present at the moment when this automobile was sold, because we didn't have a certainty when this Honda would be sold. So that would condition that he would be missing and he could not sell it. Again, I repeat myself, there could be a situation that could reflect this understanding that we had, but we didn't go through them, considering that I was fully trusting myself and the person who was managing the transaction. And I didn't think that such a problem could exist in the situation that when the buyer or the seller could confirm those aspects. Believe me, today identifying all these people, if there wouldn't be the situation as a de facto, they wouldn't go to the legal approach in order to confirm it after 5 years, when they just were asked to confirm a situation that took place. So that was the reality. Maybe there were existing the possibility to have a different approach in a legal way or formally. Thank you for this clarification. So you have mentioned that you have operated some loans, or short-term loans. We are in hearings and we would like to avoid data with personal data, but maybe in a written communication, could you list these people from whom you have asked for loans for short-term? You've mentioned 3-4 units. So I have offered the declarations of these people. I'm talking about Vanaga Mikhail and Gokhber Eugenia, who confirmed these situations through their written declarations and through the confirmation of their income. Thank you. And the last question related to the real estate. You have mentioned that in order to, if you are talking about financial activity of your brother in Italy, they were oriented to the savings or collecting this money in order to use them for economical activity in Moldova. And later on, because of a situation in the family, he changed the destination of investment. The question is why an apartment in this specific apartments block, considering that maybe it would be possible to cover more objectives, to find part of funds to be transferred for the investment in the economical activity, and also to buy an apartment that is not that central, maybe in a different sector or area, but that could offer the same conditions. Comfort in Chișinău, where you could be closer to your mother in order to take care of her. I understood your question. Thank you. So, at the identification at this real estate unit, I did not participate. That was my brother, together with his relative. As I understood, first of all, this apartment was attractive as price and location, as price, because for the respective amount of money, it was a favorable location, but also the owner of this apartment accepted the respective price, considering he needed to live for a few more months in this apartment. Also, this location was identified as a favorable one, considering that it's very close to the place I'm working, and considering that my mother was not moving, I needed, at least during the lunch break, to go home and to offer the support that was needed, and in the evening not to have a too long ride. Also, in order to go from Hâncești to Hâncești from this apartment in the evening, when I was offering the needed care, then going to Hâncești, that again was reasonable. So when this apartment was identified by my brother, I confirmed the fact that it would be good for me, considering the obligations that I had in this agreement. There was a pharmacy at the first floor. It was a commercial area that was procuring the alimentation products, and I could realize and cover all the needs without big efforts, or even by asking someone. And during the lunch break, I needed maximum 15 minutes in order to go to my mother, or to bring the medications, or lunch break, or the medical assistant that was visiting, and so on. But I did not participate at the identification of the apartment, and I would like to mention that at this moment this space is considered expensive. But in 2018, that was a situation that this apartment block was not over-requested. They were quite reasonable variance, considering the value of money my mother and my brother had, even for this location, in the area Telecentru. That was optimal for me to commute to work. Thank you, Mrs. Judge. As a reporter, I have no other questions. Looks like my colleagues that there are no questions from them as well. So, dear Mr. President, please.
Judge Bostan, let me ask one question before we conclude. In your statements earlier to the Commission, you said that I think you said you had learned a lesson when you look back now on the purchase of the Lexus, where you paid for part of it from the proceeds when you sold your Honda. And I understood you to say that more recently you have bought another Lexus in circumstances where you're paying part of the price with the proceeds from selling your current car, and that you've documented that differently. Did I understand you correctly?
I did not procure another Lexus. I put it on sale, but I procured another vehicle. So respectively, at the moment of procurement and sale, I have reflected in the contract of procurement sale. I had this successive payment and the act on each payment at each transaction for the procurement of a new automobile. So when I have procured it, I put on sale Lexus and it was not sold yet. So later on, after Lexus was sold, I have transferred this money on the name of the person from whom I have procured the next vehicle.
All right. Can you provide copies of those documents to us?
Of course.
Thank you.
I just don't have them right now, but yes.
Oh, of course. Okay. Then, Judge, I believe that we have no further questions. Would you like to make any closing statements before we conclude the hearing?
Yes, I would like to thank you for this opportunity, especially honored commission. I would like to point a few aspects from my vision that are fundamentally important. I am aware of the fact that within the first assessment, the Commission offered me a level of trust and credibility that was inspired from the regulation of the Law 252. The fact that, once again, I'm very, very appreciative, considering the Council of Magistracy that was at the basis of the process of evaluation. At the moment, I just want to manifest a disagreement, a full disagreement, considering that from some reasons, hope you're not just based on the errored interpretation, they were directed on the wrong direction. I refer as a priority to the reasoning exposed in the decision of the Superior Council of Magistracy regarding some situations that are contained in the decision of the Supreme Court of Justice on the contestation of decision of assessment in the process of pre-vetting.
In this regard, I would like to mention that the pre-vetting process was conducted under legal rules, regulations that are absolutely distinct, resulting or are based on Law 26 and the vetting procedure. They are compliant with the Law 252 that contain absolutely different criteria and consequences of the evaluation or of the integrity verification process. Article 13, para 6 of Law 26 states that the findings in the decisions adopted under this law, I would like to quote, do not have proving evidence-based value for any other procedures or processes. Moreover, having read the decision of the Supreme Court of Justice, this is provided in point 384, stating, I will quote again, the failure to promote, to take the evaluation under Law 26 does not influence the further career of a judge. One can easily see that the SCM, referring to the Supreme Court of Justice decision, refers to Article 123 of the Civil Proceedings Code, starting from the provisions I mentioned of Law 26, namely that all the evidence, proofs, conclusions reflected in such a decision cannot constitute cannot have proving value for any other proceedings makes inapplicable regulations, the rules of Article 123 of the Civil Proceedings Code, because these two procedures were different, distinct. Moreover, the Pre-Vetting Commission has upheld some of its doubts, and the Supreme Court of Justice, when examining the appeal submitted by myself, mentioned that such doubts constitute an opportunity for the Commission, and the Supreme Court of Justice shall not engage to give its assessment to some opportunity-related issues, but it rather shall check aspects related to pre-vetting only to identify any procedural violations, only violations of procedure. They shall not assess the fact-based conclusions, financial-based conclusions, did not constitute an object of the Supreme Court of Justice examination under my appeal. Therefore, the decision dated July 2024 refers expressly to such moments. Last but not least, I would like to mention and communicate to the Commission the opinion dated 13 December 2021 on the number 1069 of the Venice Commission and the General Department of this Commission, which, when they provided an assessment to such proceedings, mentioned that the draft law of 26 that was revised shows clearly that results of integrity assessment as part of the pre-vetting procedure shall not have any effect on or impact on the candidate's career. This situation was absolutely ignored, in my opinion, by the SCM. Therefore, I kindly ask you to take into account these arguments that I am providing now to you, and I stay hopeful that this evaluation shall be an objective one. It shall start from the presumption of proofs, the information that cannot be overturned just based on doubts, but shall take into consideration as part of the whole proofs and evidence and information provided by myself. Allow me to mention once again that my activity as a judge, and therefore my work as a Moldovan citizen, maybe was not exemplary of the absolute discipline or the absolute and the best financial records, as I was not aware of the pre-vetting full procedures and provisions. These situations has been an exercise, a rather complicated exercise for myself. I stay hopeful to undergo an objective assessment and an analysis based on fully real analysis based on the proofs and information I have provided. And apologies if I has been even more emotional towards the ending of this statement. That's it from my side.
Judge Bostan, thank you for your submissions to the Commission and for your statements at today's hearing. This brings us to the conclusion of the hearing. After the hearing, the Commission will approve an evaluation report stating its conclusion whether the subject meets the criteria for ethical and financial integrity under law number 252. The Commission will strive to complete and approve its evaluation report and announce its conclusion as soon as possible. Today's hearing is now closed.
Mr. President. Mr. President, before you close, you have asked for certain documents to Mrs. Bostan. Mrs. Bostan, could you provide the Commission with these documents before the end of this week?
Yes, tomorrow I will scan and send them to you via email.
Thank you. My apologies for the interruption.
No problem. Does anyone else have anything? Well then, good day to everyone. Poziguna.